So mediation is part of litigation. You don't get to litigate unless you mediate. I will tell you, in my view, the best way to be sure that you're able to come to a result in mediation is to be 100% ready for litigation. And that means that when we're at the mediation table, the other side knows we got our ducks in a row. We can prove everything that we need to prove. We've got the documents to show who's been the primary caretaker for the child. We are ready for trial. There's nothing like sitting in a mediation table and knowing that that other side can completely destroy you in a courtroom to make you want to settle. Well, that's what we want for our clients. When we go to a mediation room, we want the other side knowing we are not afraid of the courtroom. We are ready for the courtroom. And if they want a good agreement, they better be willing to be reasonable. The longer a divorce goes on, the more it's going to cost. And that's why we like to get to the mediation table as quickly as possible. That's why we're preparing your inventory and appraisal from the first meeting. If we settle in that mediation room, you don't have to pay for your attorney or paralegal to go into the courtroom, to muster all those documents together, to print out enough to kill a small forest in paper, and sit there in the courtroom just hoping that the court has time to hear you. If you settle your case at mediation, you know you've got an end in sight. You know the agreement that you're going to get. And you're no longer at the mercy of a judge's calendar and how much time that they can give you. If I can get a good agreement in mediation, I'm always going to do it, because my client gets to help craft their future. They get to have a part in dividing their assets. They get to have a say in their child's schedule in the future. You don't get that in a courtroom. If I can get my client what they need, what they want at the mediation table, I'm always going to do it. It's faster and it's cheaper than going to court. But the best way to know that you got what you really need at mediation is to be ready for that courtroom. Overwhelmingly, my judges are going to require that parties mediate. Even if you desperately want to go to trial, even if you filed a demand for a jury trial, you're still going to mediate. There is one exception in the code that says if somebody has been a victim of domestic violence, that the judge can order that they don't need to mediate because they would be intimidated. I will tell you, I have represented people who have been victims of domestic violence. Most of the time, you're not in the same room with the perpetrator. You don't even have to be in the same building with the perpetrator. I usually like to mediate those cases too. And I like to mediate those cases as well, because it is amazing how much you can get somebody to give up in negotiation when they know that you are just prepared to crucify them in court. And when you've got somebody who's been a victim of domestic violence, real domestic violence, yeah, you can get out of mediation. You probably don't want to. Trial is expensive. Divorce is expensive. If you are going around and talking to divorce attorneys, you might be hearing from a bunch of different divorce attorneys. Well, I have a $5,000 retainer, or I have a $10,000 retainer, or I'll just start with $500. Pay no attention to that when you're thinking about how much the divorce costs, because what most of them are not going to tell you is that the average cost of a divorce in Texas is over $28,000. And so if they are roping you in by saying, hey, I'll start with a $1,500 retainer, what they mean is, I'll take your money and you sign your name and you'll pay me more later. Now, that being said, there are some steps that we can do to try to conserve funds for clients. And one of the things that we can do is settle as early as possible. So as soon as we get your documents ready, as soon as we've got a working inventory and appraisal, we're pushing to schedule that mediation. And if you settle at mediation, well, then you're not paying your expert witnesses to come to court, and you don't have the emotional turmoil and cost involved in the divorce going on. You don't have to worry about standing in the witness box and being cross-examined while the court reporter takes down every word you've said. And trust me, you're going to mess up on a few words. Everybody does. And the other lawyer, they're going to be there to catch it. So if I can get a good agreement at mediation and I can save my clients the emotional cost of trial, the financial cost of paying us all to print out that documentation and to be there in the courtroom, I'm going to do it. We can save you a lot of money with a good settlement at mediation, but you're only going to get a good settlement at mediation if, when it comes down to it, you're willing to go to trial. I'm Ruby Bolton, the founding attorney of the Bolton Law Firm. If you have found this video helpful, please click below. We have more information that we'd love to share.